Hi, everybody. This is a long-awaited update in our podcast series, True Crime Arizona, Lori Vallow's Deadly Delusions. I'm Morgan Loew, and I'm here with my partner, Amy Cutler. Today, we're going to discuss the latest developments in this case, and there are several of them.
Yeah, we want to get right to a quick rundown of the headlines. First off, Lori Vallow claims she has an alibi. People who can vouch that she was not involved in her kids' disappearance and murders, Tylee and JJ's murders, and that's not all. Lori wants the court's permission to have meetings with Chad Daybell, her now husband, and she doesn't want those meetings recorded. Also, Lori's attorney says they will not be using a mental health defense at trial.
Those are some big headlines and big developments, and we're going to get into those in detail here in a minute. But first, Amy, you've been looking at what is happening now. So let's just start with this. Where does the case stand at this point in time?
Well, Lori and Chad remain behind bars. Their attorneys are working on these cases. The trial is set to begin in April. So, it's been several months and they're working these cases. And now they've filed these motions in the last week.
And so the trial is set to start in April, but it may get delayed.
Exactly. Chad Daybell's attorneys are asking that the case be pushed back to April of 2024. The evidence that the prosecution is supposed to hand over is supposed to happen by February 23rd. His attorneys are arguing that's just not enough time for them to go through all of that and then start a trial in April. So they are asking for a full year delay. I had the chance to speak with a criminal defense attorney today. He tells me he expects that request is going to be granted because when it comes to death penalty cases like this, they really want to follow all the procedures and protocols, really check everything off the list. And if they're saying they're not going to be prepared, he tells me he thinks that they're going to get that extra time.
Yeah, it's not tough to understand how if you're the defense and the prosecution is just turning over key evidence in February that in a case like this, parsing through everything, interviewing witnesses, trying to do your part to take apart the prosecution's case, that 2 months may not be enough time. So probably not a stretch to say that this trial is not going to start in April, and it could be another year. And that's not uncommon with capital murder cases. So moving on to some of the headlines here that you talked about, the one that struck me when I saw this court filing by Lori Vallow's attorneys said that they're providing a notice of alibi. And I'm going to read straight from the court filing here, and then we're going to discuss this. It says that Lori Vallow was in her own apartment in Rexburg, Idaho, when J.J. Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Defendant was with Melanie Gibb, David Warwick, and or Chad Daybell. And Lori Vallow was in Hawaii when Tammy Daybell died in the home of Chad Daybell in Salem, Idaho. Defendant was with Melanie Boudreau and or Audrey Baratiero. So what the defense is saying is that when these kids, or when JJ died and when Chad's wife, Tammy, died, that Lori was with people and the implication is she was not involved. That sounds pretty significant to me.
Yeah, I agree. It's really interesting to hear now that she is saying that her 2 kids were killed in the apartment that belonged to her brother, who was living at the time in Rexburg with her, Alex Cox. It is a big development, and the local criminal defense attorney that I spoke to earlier today was saying that he believes they're going to have to back this up with some kind of evidence at trial to show, and that she might know more about how they were killed and what specifically happened.
Yeah, and let's listen for a second to what he told you about this.
In Idaho, there is a rule, and it says if the defendant is going to put forth an alibi defense, they need to disclose that in advance. So the disclosure itself is nothing unusual. It's just something that's required by Idaho procedure. From what's interesting about it is it's telling us that Lori Vallow's defense team knows when these children died. So, which is information that, the general public just doesn't have at this point.
So that addresses some of the legal maneuverings and legal requirements there. But there's one big point that is sort of buried in this court filing. And that is that Vallow's attorneys are blaming the murders on her brother, Alex Cox. They're saying he's the one who killed the kids. Not saying who may have killed Tammy, saying he's the one who killed the kids. And that is pretty significant. Let me tell you what I know about Melanie Gibb and David Warwick. So this came out during the preliminary hearing a couple of years ago in Idaho. Melanie Gibb and David Warwick, who were dating at the time, Melanie is a friend of Lori's, a former podcast friend of hers. They were staying with Lori the night that prosecutors and police allege JJ was murdered. And Melanie Gibb and David both testified in court that they were with Lori that night, but that they didn't know anything about JJ disappearing. So we knew that they were there, but now Lori is saying they're my alibi. So is there other information that they have? Did they have eyes on Lori the whole night? They didn't testify to that in the preliminary hearing, but maybe there's something, maybe there's something new. Maybe there isn't. But that is really, really significant. And then the other part, that Lori was in Hawaii at the time that Tammy died. We knew that. And that Melanie Boudreau was with her. So, what they're saying is we have an alibi. So in essence, she was not involved. Prosecutors have never made any allegations that Lori was the killer, that she physically killed the kids. They're alleging a conspiracy here. And so they're going to have to come up with some evidence. Maybe that's some of the evidence that they're handing over the defense, that they have connected Lori to the string of events that led to the deaths of these children and or Tammy Daybell. Interesting legal maneuverings. Not, as far as court filings go, this is not out of the ordinary in a murder case, but it is significant because this is the first time we've seen some of this on paper from Lori's attorneys.
It's also interesting to me because Alex Cox later died of natural causes. So it seems convenient to mention him in these filings when it's not like he can come to court and present his side of things. He's no longer with us. And so it seems like sort of an easy way to kind of place the blame somewhere else.
Yeah, and prosecutors in their filings, have sort of made the case, and detectives, that Alex Cox was likely the person who murdered the kids. And he's no longer here to say, I did it, or I didn't do it, or I did it because my sister told me to do it. We're not going to hear from him. So that is a convenient situation for the defense in this case. It is much easier to blame somebody who is not there to defend themselves or to explain what really went down. So that is one set of sort of bombshell headlines. The next one, and which I thought was really interesting, and Amy and I were talking about this before we started recording the podcast, is this petition to allow the defendant and her attorneys to meet with the co-defendant and his attorneys in confidential joint settlement and strategy sessions. What does that mean? Lori wants to meet with Chad. So that's interesting, but there's also a line in here, and it says, the two have spoken by phone only one time since June 9th, 2020, and that was an arranged phone call on July 26th of 2022 between the parties and their counsel. So Lori and Chad have not spoken in years now.
Yeah, almost 3 years.
Yeah, and most of the people listening to this podcast, and we're reporters, we don't really know what it's like when you're behind bars in a case like this. Are you allowed to make phone calls? Do your lawyers allow you to make phone calls to people you want to talk to? In most cases, the answer is yes, but the issue here is they are co-defendants, and we have to assume that there are forces outside of the spotlight who are trying to get one to testify against the other, potentially. So what does this mean? Does this mean that they have agreed not to speak to each other? Does this mean that their attorneys have told them not to speak to each other? Does this just mean that their attorneys say it's not a good idea to talk to each other because these phone calls are always recorded? So they filed this filing that says here, I'm going to read another part. Lori and Chad would like to be able to talk together in person and on the phone about their options. And they would like those conversations to not be recorded, and agree that those conversations would not be used as evidence. So that's their lawyers saying, whatever you talk about, we're not going to use it against each other. And they also don't want prosecutors to be able to get that. You see these, this has been a very high-profile case, high-profile proceedings. This husband, wife, who allegedly committed these terrible crimes so that they could be together. And now we find out that they haven't even spoken in 2.5 years. That's pretty interesting. That's an interesting development, revealing that.
Do you think it says that they are, obviously right now they're being tried together, but that's how they want to move forward in this?
That is whether or not they will end up being tried together is an open question. And I sort of suspect that depending on how these conversations go, they may ask for the cases to be separated. The judge may agree with that, or, they could be tried together. I don't know. There are pluses and minuses. As far as legal strategy goes, I think if I were representing one of them, I would rather try the case separately. Although if they are tried together, it means that they are not going to testify against each other. So that's the plus. Try them together. They're not going to testify against each other. You try them separately. You're in charge of your own client's defense, and you're in this sort of bubble, but you have to worry about what the other client is going to say about them. So I don't know. I think that's a really interesting legal question that you pose there, and we'll find out. That's for sure. So then the next sort of headline here has to do with this idea of mental health defense. And Amy, what are they saying about the possibility of Lori using a mental health defense? Because she was found to be not competent in the past and then rehabilitated. And now what are they saying?
Now her attorneys are saying that she is not going to use mental health in her defense, which is kind of an interesting twist in this, because given her stay in rehab and all that talk, there was some speculation that they might go that route, and they've chosen not to do that. So it's kind of interesting to see where they're coming from on this. Although, I guess if they have this this alibi explanation, then maybe they feel like they don't need it.
Yeah, so I'm reading their filing here again, and it says she spent 10 months at a mental health facility in Idaho. We reported on that in the past. On October 15th of 2022, the court ruled that Loew was competent to stand trial. Now they're saying here, her lawyers, although she is still suffering from a mental illness, the defendant is taking an active role in her defense. And that's sort of a necessity to show that she's competent. And it says she does not want to proceed with a mental health defense to negate an element of a crime in this case. So it's not going to be not guilty by reason of insanity. That's, according to this, out the window. Now, if she is found guilty, they could bring in mental health issues to mitigate a penalty. She can't be put to death because she's suffering from mental illness. The reason she's suffering from mental illness make her more sympathetic in the eyes of a jury. Maybe her punishment would be less. That's where a mental health issue would come in. But they're saying, they're not gonna say not guilty by reason of insanity, which is the opposite of what's happening in this other case that we're covering, the Brian Miller, the zombie hunter trial, where that's what the defense is going for. So they've drawn a line in the sand and said that's not going to be the case here.
Listening to you read that, it almost sounds like Loew doesn't want them to use that as part of her defense. Is that something she could request that her attorneys do?
Absolutely, and that's exactly what she's done here. I'm reading again here. It says, she has not authorized her attorneys to proceed with a mental health defense in the guilt phase of the trial. Her attorneys are respecting her autonomy and her rights granted to her by the Constitution. So she is obviously here taking part in her defense and ordering the attorneys, this is what I want to do, and this is why. So, it does appear that whatever mental health issues she's facing, they're not getting in the way of her assisting them with her defense. One of the other things that all of these court filings sort of play into is this idea that she could face the death penalty. And that's another filing that her attorneys, this was a busy week, another filing of her attorneys made a motion to declare the defendant not eligible for the death penalty. And this is it's not a lengthy motion, but it's pretty interesting. And what they're saying here is that they would like the court to say she can't be put to death even if she's found guilty. And what they're saying is she didn't have the requisite culpability to be charged with death under this indictment for conspiracy to commit first-degree murder, or principal or accessory to first-degree murder. They're saying that, they're arguing because she had the alibi, she wasn't there when the murders took place. They're arguing that whatever role she might have played in this did not have the requisite mindset that she needs to be put to death. And they bring up a couple of sort of felony murder cases, that felony murder law is if you are committing a felony crime, a violent crime, and somebody dies in the commission of that felony, you can be charged with murder because what you did created that situation that caused the murder. And so they looked at a couple of cases that look at this, that use the felony murder to find people guilty and put on death row. One of the cases they bring up is Tyson v. Arizona. And if you've been in Arizona for a long time, as I have, you knew what the Tyson gang was. And there were this family, these kids, and their dad. The dad and this other guy, his name eludes me right now, but I covered his execution later. And the kids helped the dad break out of prison. And then they went on this sort of rampage. There's been movies made out of this case. And so they ended up all being caught. The dad murdered a couple of people while they were on the run. And they were all caught. And the Tysons were later charged with capital murder under the felony murder rule. And each of them was convicted of the murders under the accomplice liability and felony murder statutes. And the Supreme Court upheld that the kids could be, even though they didn't pull the trigger, that they could be found guilty of first-degree murder there, felony murder, because their level of participation in this crime was major, not minor. So the Supreme Court said, if you have a major role in the situation that results in the murder, you can be held liable for that murder. And what Lori Vallow's attorneys here are saying is that she did not have any major role in these murders. And so what we're seeing is the first glimpses of what her defense is going to be like. If she did play a role, it was not a major role, and therefore she should not be eligible for the death penalty. Now, is that going to work? We don't know. The judge will decide this before any trial occurs. So this will be ironed out before a trial comes up, but this is their first real sort of play to spare her life. And I imagine it's going to be the first of many. I don't know. Amy, what do you think?
Well, it's interesting because I wonder, is this standard in a death penalty case, would you say, that they do, for lack of a better explanation, you throw it all out there and see what comes back. Is
Yes.
that sort of what they're doing here? Or do you think that there's more of a method to the madness here?
I think it's standard to throw the spaghetti against the wall to see what sticks if you're a defense attorney and you have a tough case. And this is a tough case. This is pretty interesting because they are using, some real precedent here, but it doesn't quite apply cleanly to Lori Vallow's situation. So, it's an open question whether the judge is going to agree with this. And I'm curious to see how the prosecutors respond to this, because they may find some cases that are more similar to Lori's where the death penalty was upheld. I don't know. There's a lot of legal wrangling and a lot of legal wrangling to come. And this is really the first significant slew of filings that we've seen that are giving us an idea of, okay, what are the tactics that the defense is going to use here? And now we have a little bit of an idea.
And important to note, Lori and Chad are due back in court on the 19th, so next week. I think it's safe to assume the judge is going to address at least some of this at that hearing. And so we're going to be monitoring that closely, and we will follow up with new episodes as we get any new information on this case.
All right. Thanks, everybody. And you'll hear from us soon.
This is True Crime Arizona, an Arizona's Family Originals podcast.